Welcome, everyone, to today's workshop, The 5 Most Important Decisions I Should Make to Protect My Family Now and Forever. We thank you for being on today. This workshop is being recorded, and all participants will receive a link to the recording within the next few days. My name is Patricia Clay, and I am the Director of Operations and Client Services here at the Law Offices of John K. Hilton. Before we get started, I want to take a minute to make sure you can hear us and see our screen. In the question box, please type the number 1 if you can hear me. Great, it looks like you can hear me. If you cannot see my screen, please type the number 2 in the question box. Okay, let's get started. With the overload of people on the internet, sometimes screens can freeze up. We appreciate your patience if this happens. There will be a question and answer period at the end, but John's workshops are interactive, so feel free to post in the question box at any time, and we'll be sure to answer your post. Finally, John will be offering a special gift to you, so please stay until the end to hear about this gift. Again, thank you for attending. So without any more delays, I'd like to welcome John Hilton.
Thank you, Patricia. Hello, everyone. I'm so glad you're here with me tonight. We are all about the 5 most important decisions you should make to protect your family now and forever. This is a serious topic, but these are seriously the most important decisions you can make if you want to ensure your family is protected from court and conflict when you become incapacitated or die. I have to apologize. I have a little cough, and so I'm going to try to not do that too much, but if I do, just understand I'm trying to get over a cough. So my name is John. I'm a dad, a husband, and an estate planning attorney, and your life and legacy lawyer. So I want to thank you again for being here today. I'm honored to be able to spend a little bit of time with you. We're going to jump right in, but if you haven't already done so, if you'll look in your taskbar, go ahead and download the workbook so that you can take notes and follow along with me. The link was also in your reminder emails leading up to today. And so either go into your email or look in the taskbar, you should see a PDF of the participant workbook. And so go ahead and either download that, print it out if you want so you can write in it, but have that available as we go through this. Now, the best way to learn is to go ahead and turn off your cell phone, close your door, and turn off any background applications, email, things like that that might be popping up on your screen, because I really want you to get the most out of your time with me. And I want you to be able to focus on the things we're going to be talking about and on the questions I'm going to be asking as we go through this. And this will be, make your time more valuable if you turn off any distractions. Before we move on, let me introduce my family and my reason for doing what I do. I have my wife there on the top left, and between us, we're a blended family, so we have 5 boys, and you can see there, 2 of them are married and have children. One on the bottom right, that's his engagement picture. So the family's growing, and this is why I do what I do. If you look at the bottom left of your screen, you see my son Anthony, and Anthony has autism, and so I really like to work with families of children with special needs. But this is what I do. This is why I do what I do, because it's not about me. It's about making sure that my family, when I am incapacitated or I'm no longer here, has everything in place, and they don't have to go to court. They don't have to have conflict after I die. Here's one of our clients gave us this referral, and I really like it because it really, I think, captures what we're about. So we found John and Patricia both to be very personable, easy to understand, and helpful. We feel as if we've known you both for a long time, almost like family. And I think one of the things that I hope that you'll get out of this as we move forward is that relationships for us is what it's all about. And we love it when our clients think of us as almost like family. Now, I know your time today is precious. I want you to know it's very well spent. And if you stay tuned till the end, I'm going to share a link with you for a complimentary one-on-one meeting with me personally, in which we'll talk about you and the people you love most and how you can protect them. I will also have a special gift for anyone who schedules time with me immediately following this workshop. This is important because I only take a very limited number of new clients a month. I have helped many families with their estate plan, and I do have a lot of experience doing this, and you would think maybe I would take anyone who wants to do this planning with me. But the reality is that I limit the number of these appointment slots because I like to take the time to become well acquainted with my clients. I like to give my clients the full amount of time we need to get their plan exactly right. And I can't do that if I'm cramming clients into my schedule and that I don't have time to really provide the service that I think my clients actually deserve. So I only do this with clients who take the time to get educated about these decisions and who agree to do a little bit of homework before meeting with me. So now I really want to talk about you. This would be a great time if you've downloaded the workbook, if you've printed it out. It'd be a great time to start open that up and start working in that. And the first section is called My Reality. So as we go through this, think about what your reality is today and go ahead and start taking some notes in your workbook. So kind of like to get a sense of where you are in this whole process. And I'm really curious if you'll type into the question box for me. Do you currently have an estate plan in place? This includes any estate planning documents whatsoever, healthcare documents, a will, a trust, anything like that. And if you'll just type in yes or no in the question box, that'll give me an idea. Okay, so it looks like right now I am seeing four of you say no and one yes. All right, excellent. So what you're going to see is that that's pretty typical. 4 no's and a yes is about the right ratio of those who have a plan. So if you don't have a plan, you're right in there with almost everybody, most adults today. Right now, statistically, about 62% of adults have not done any estate planning, don't have any documents at all in place. And if you're talking about adults with minor children, then it's an even much higher percentage who do not have any planning in place at all. So I kind of like to know, if that describes you, why would you say you do not have an estate plan in place? Are you too busy? Do you feel like you're too young? Do you think it's too expensive? And if you would, just go ahead and type into the question box your thoughts on why you have not done any kind of planning yet. Okay, so somebody said Well, I know I should, I've just never gotten around to it. That's fair. That's true of almost everybody that we talk to. Somebody else said, well, I didn't think it was important until I became a parent and started thinking about my children. That's great. You know, for most people, there's not a big reason to think about it until your children come into your life. So here's one that says, you know, I just never thought about it until my mom passed away and I had to go through probate with her. So now, you know, mom's passed and they've experienced what that's like and they're wondering what they need to do for themselves. That's great. Somebody, I don't know why I've waited, but I know I need something. So these are all very valid reasons, and we'll talk about all of these as we move forward. So if you do have an estate plan, what do you hope to learn today? Let me know what comes to your mind. You can go ahead and enter in the question box for me. What do you hope to learn today if you do have an estate plan? Okay, so somebody said they just want me to cover everything. So that's great. We're going to do that. Let's see here. Here's one. I did my will on rocketlawyer.com, but no, that's not enough. Excellent. So we're going to talk about that as well. And I think there may be gaps in my plan, but I don't know where. Okay, so this is all absolutely perfect. We're going to discuss all these questions and more today as we move forward. So I guess kind of all this comes together to why did you take the time to log in and spend some time with us today? And, you know, we just discussed a few reasons, but I'm kind of curious, and maybe you could go ahead and you know, put your answers in the question box, but, you know, maybe it's for one of the reasons we just discussed. Maybe COVID-19 has made you realize that you can't really predict when your time will be up. Maybe it's because you realize that if you're hospitalized, you haven't made any selections for who would make healthcare decisions for you. Maybe you've heard about the new tax law and wonder if it applies to you, the Secure Act. Maybe you're curious about how to protect your assets after they're transferred to your beneficiaries and make sure that your beneficiaries can't lose them to divorce or something like that. Or maybe, like, you know, one person said, you just don't know what you don't know, and you hope you can find out if there's any gaps in your plan. So if you have any thoughts like that, if you would share them with me in the question box, that really kind of helps me know what you guys are thinking. And while you're doing that, I'm going to move on. I want you to know, you know, all of those are reasons and things that are perfect reasons for you to be here. I want you to know you're in the right place. If you have someone or something that you care about and want to protect, we're going to help you with that today. It doesn't matter if it's something big or something small, something expensive or not, but we're going to cover the 5 most important decisions you should make to protect your family now and forever, and we're going to cover all those reasons that we just talked about. You're in the right place if maybe you did a fill in the blank will. You created a document online, but you don't know for sure that you did it right, that it's going to fully protect your family. You know, what are the supposed risks of doing do-it-yourself estate planning or online planning? So if you ever thought about that, maybe that's the position you're in the right place. This isn't the big question. How much does estate planning cost? Well, we're going to talk about that. I understand that's a big question, and we want to make sure that you have all that information before you make any kind of decisions about estate planning. Because at the end of the day, what we're really talking about is estate planning is not about you. It's about the people you love the most. Your loved ones will know how well your plan worked or not when that time comes. So, sometimes we have clients come in, and one of their loved ones will pass away and said, but mom and dad, they told me I took care of it. Don't have to worry about anything. And now I don't understand why we're having to go to court, or why we're having to go through all these extra steps, and why we're having to publish in the newspaper all this. I thought they told me they took care of it. And so this is what we help families do, to truly take care of it, to leave no stone unturned and make sure loved ones aren't confused or caught off guard later. So I'm going to get started. I start with the first most important decision you should make to protect your family. Ready? Here we go. The first important decision you should make is get organized. And it sounds simple, but you'd be surprised how many people get stuck right here. I have a question for you. Would your family know where to find all of your banking accounts, your IRAs, your life insurance policies, your investment accounts, your business records? What would happen to those assets if your family can't find them? Well, the reality is that most of that will end up in the Arizona State Department of Unclaimed Property. And right now in Arizona, there's about 1.4 to 1.5 billion with the B dollars of assets in the Arizona State Department of Unclaimed Property. Most of that got there because someone died and their family overlooked an insurance policy, a bank account, an investment or retirement account. And this could easily happen to your family if you're not financially organized at your death. And so, one of the things, that we work with clients right off the bat is get organized. And so I'm going to back up a bit. So you see this picture. In fact, I'm going to back up a couple so you can see it clearly. This girl, if she were looking for your assets, mom or dad died, and she's trying to figure out, well, I don't know, where's her life insurance policy? I don't know, what were their bank accounts? This is what it feels like when you're not organized. But when you get organized, it becomes easy, and it allows your family to locate your assets and ensure that nothing gets lost to the State Department of Unclaimed Property. And why would you ever want something to go to the State Department of Unclaimed Property? It's just a huge abyss of assets, and it should go to your family. So there's basically three things that we encourage you to do. Start with organizing your estate and business records. Make sure you have all of, if you own a business, all of your business records are in one spot. All of your estate planning documents together in one spot. And then we encourage you to create a spreadsheet listing all of your assets. And I'm talking about every savings account, every banking account, every vehicle, your house, your investments, your life insurance policies. List those, list your account numbers, your policy numbers, put all of that down, and also list your advisors and agents so that when something happens to you, your family knows who to call about those assets. And then another thing that's super important, guys, look on your life insurance and retirement plans and make sure you have the right beneficiaries listed. We've had clients come in who have forgotten to change their beneficiaries. And if something happened to them, their $100,000, $500,000 life insurance may not go to their wife and family. It may go somewhere else, and that's not what they would have wanted. So that's a big part of getting organized, making sure that all of your beneficiaries on these assets are correct. So right now, if you look in your workbook, go ahead and complete section 1. It says, keeping my assets out of the State Department of Unclaimed Property. Go ahead and do that, and I'm going to move on. So this is the second most important decision you should make. And these aren't necessarily listed in order of importance, but they are listed in order of how to progress through them. So getting organized is not more important than protecting your children, but it's one of the first steps you should take. So, I hear a lot, people who I speak to who've already done a will, and they say, John, I've already named guardians for my minor kids in my will. And I can look at their will and say, yep, sure enough, if I die, I nominate so-and-so to be the guardian of my child. But what they don't realize, and what I'm going to tell you tonight, is that may not be enough. And I'm going to go through the next couple of slides and you'll see that. But for right now, while I do that, go ahead and start working on section 2 of your workbook and about your children. So let's consider a hypothetical situation. You're fatally injured in a car accident, leaving behind 2 small children. You have a brother who is very successful, has a stay-at-home wife, and 3 children who are excelling in school and sports. You have a sister who has a good job, but she's not married, she has no children, and she lives in an apartment. Now, both your brother and your sister petitioned the court for guardianship of your 2 children. Based on the above information, who do you think the court would decide is the best candidate to raise your children? The married, successful brother or the single sister? So I would invite you, go ahead and go into the question box and just type in brother or sister. Give me your vote. Okay, yeah, so, most of you are saying brother, one of you said sister. So the reality is we really just don't know, because this is a court, this is a human judge, and either one of those could be selected by the court. But now let's add in an additional fact to your brother's situation. Now let's add in that your brother's stay-at-home wife is actually a closet alcoholic and abuses prescription drugs. Turns out the only reason his kids are at all successful is because he makes sure they're protected from their mother's addictions. Does that change your answer? Do you think maybe now the sister might be a better option to raise your children? But how would the court ever know that? So let's assume now that you were not fatally injured in the car accident, but you were in a coma. Your will indicates that you prefer your sister to raise your children because you know that your brother's wife abuses alcohol and prescription drugs. But here's a problem. You're not dead. You're just in a coma. So your will is not ever even considered. So who will take care of your children? Who will care for them while you are incapacitated and in a coma, but you haven't died yet? Because your will only covers what happens when you die. So let's take a look at this. If you do have minor kids at home, I'm going to tell you 2 very quick stories that illustrate where your kids are at risk, even if you've already named guardians in a will. So if you have not named guardians in a will at all, 69% of parents have it, so you're in good company, and something happens to you, The choice about who raises your kids will be left to a judge to decide. Now, several years ago, and you guys might remember seeing this in the news, but the Barber family, is 2 parents and 3 sons, were traveling through Arizona for vacation. They were from California. While traveling in Arizona, they were involved in a car accident and both parents died. The boys lived, and when the authorities finally found a family member to pick them up, they ended up with one of the sisters of the mom, so the boy's aunt. And their mom's sister decided that she should get custody of the kids and their money. And she prevented them from seeing any of the other family members. After more than $100,000 in court costs and a year of litigation and a huge family fight, a judge finally decided that a different sister should raise the boys and appointed a financial conservator over the boys' inheritance to the tune of $100 an hour. The boys will receive whatever is left over at the age of 18. So, we got a story of, an abuse of privilege. $100,000 of what should have been the boys' money is already been spent in court costs. And now a stranger is going to be controlling that money for the boys and charging their account $100 an hour. I don't know how much money they actually inherited, but when they turn 18, they get the rest of whatever that is. Let's look at another story. So maybe even if you have a will, naming guardians, for your kids, they could still be at risk. A really good friend of mine realized this. She is an attorney. She was out to dinner with her husband, and her baby daughter was at home with their 16-year-old babysitter. And she realized that although she had named guardians in her will, they all lived across the country, and no one would be able to find her will anyway because she hadn't told them where it was. And so she's sitting there at dinner, and she realized that if something happened to her and her husband, the authorities would have no choice but to take her daughter out of her home and into the care of strangers until they could find her will, locate her named guardians, and they could figure out how to make their way across the country to her to take guardianship of her children. She said, well, this is not right. I can't, I never want my children to be in the care of strangers, in the foster system. And so she did the research, and she created something we call the Kids Protection Plan. And its sole purpose is to ensure that your kids are never at risk from that happening to them because of a gap left in a will or a will only plan. Because wills only serve the purpose when you die. And if you don't have people who know exactly where your will is and who are close by, your kids could end up in the care of strangers while everyone and the courts figure that out. So I'd be happy to discuss, if that is an interest with you, when you schedule your life and legacy planning session with me later on, I'll be happy to discuss that with you in greater detail. Let's talk about another thing that comes up frequently. Another reason why you might want this kids protection plan. And I'm surprised at how many times clients talk to me about this, but if there's someone in your life that you would absolutely never want raising your kids, a will is a nomination, but it does not exclude anyone else from petitioning for guardianship. So anyone in your family, anyone outside of your family can petition the court for guardianship. And if there's somebody that you would absolutely never want raising your kids or challenging your choices for your kids, through the Kids Protection Plan, we actually can create an exclusion document that goes to the court if that person ever comes forward and wants to raise your children. So here's the bottom line. If you do not have proper and complete legal planning in place to protect your children, a court will decide who will care for your children in the short term while it sorts out who will raise them in the long term. And if you don't have a way to let the court know who you believe should never be allowed to raise your children, the court has no way of knowing, and that person could end up caring for and raising your child. So hopefully by now you've completed that portion of your workbook. While I've been talking, we're going to go on to the third important decision you should make. So while I tell you another story, I got lots of stories tonight, but while I tell you the following story, I'd like for you to start completing section 3 of your notebook, planning for your financial incapacity. So Bill was an 84-year-old multimillionaire. Bill made his fortune trading on the stock market. One day he met a 25-year-old video store clerk and started teaching him how to make money trading stocks. And after a few months, Bill gave this video store clerk $14,000, and he challenged him to invest it and turn it into as much money as he could. You know, $14,000 to Bill was like handing somebody, you know, a couple bucks, a $10 bill to most of us. So he didn't think much about it. But Bill's daughters learned about this $14,000 gift that he made to this video store clerk, and they immediately decided that Bill had lost all judgment and all of his capacity to make decisions about his money. And they petitioned the court for emergency guardianship and conservatorship. Now in Arizona, guardianship refers to control over the person, and conservatorship refers to control over financial affairs. And after months of hearings, the court ultimately granted the daughter's petition and appointed one of Bill's daughters as his guardian and conservator. As a result, Bill lost all of his rights to drive, his right to vote, his right to determine where he would live, and his right to determine who his friends could be. He also lost all of his right to control any of his money. Now remember, Bill is a multi-millionaire. So during the final hearing, after the judge had made his determination, Bill pleaded with the judge to appoint anyone other than his daughter. He told the judge, you know, that my daughter is a mean and ugly person. She's been trying to get control of my money for years. But the judge had already made his decision, and he would not be dissuaded. So Bill appealed to the Arizona Court of Appeals, and he appealed to the Arizona Supreme Court, and still could not get that ruling changed. So Bill's life, as he had once known it, was over. What could Bill have done differently? Well, part of planning for your physical incapacity, Bill could have created a power of attorney in which he named his personal choice for who would control his assets when he was no longer able due to incapacity. And even if the court had decided that he needed a physical guardian, the guardian would not have gained access to Bill's fortune because Bill would have named an agent in his power of attorney. Even better, Bill could have transferred all of his assets to a trust and named a successor trustee to manage his financial affairs for him when he became incapacitated, could have avoided the entire court process completely. So on your worksheet, you should be looking at planning for my incapacity and answer those questions there and see where you stand. So number 4, we're going to move through these fairly quickly. The fourth important decision you should make is planning for your physical incapacity. Now, we've talked about what would happen to your kids if you have minor kids, what would happen to your financial assets if you became incapacitated during your lifetime. But what happens to you if you become incapacitated? So I'm going to tell you another story. And while I tell you this story, start looking at section 4 of your workbook and filling that out while I go through this story. So there recently, just this past spring, there was a young couple who got engaged. They were happily planning their wedding. And then the groom-to-be became ill and was hospitalized with COVID-19. Within 1 day, he was in the ICU and on a ventilator. His fiancee tried desperately to get the hospital staff to tell her what was going on, but because she wasn't a blood relative, they refused to tell her anything. You know, she pled with them, but I'm his fiancee. Sorry, you're not family. We can't tell you anything. And obviously, you know, he wasn't able to give permission for the healthcare staff to speak to her because he was in a coma. He was intubated. And because it was COVID-19, she was not allowed to even enter the hospital or try to visit him at all. So a couple of days after this, you know, this love of her life, her fiance was admitted to the hospital. She finally got a hold of someone in the ICU who told her that her fiance had been moved to a different floor. She was thrilled. She's like, oh, great. You know, he must have gotten better. Doesn't need the ICU any longer. And after calling around all day trying to find him, she finally discovered that he had not gotten better. He had been moved to the morgue. He had died. So what could this couple have done differently to avoid this heartbreaking end to their happy romance? Well, one decision they could have made that would have allowed her to speak with the hospital staff and keep abreast of his progress would have been to go ahead and create immediately healthcare powers of attorney and living wills, naming each other as people who could help make decisions for them, or who at least had the authority to speak to the hospital staff about their condition. So here's an older story, and you guys may recognize who this is. This is Terri Schiavo. And you may recall that back in the 80s, Terri Schiavo, what they believe now is that she had an eating disorder, and as a result of that suffered a cardiac arrest, and once she was resuscitated had been oxygen deprived for so long that she had brain injury. And her husband actually of several years felt like that the proper thing to do for her was to take her off life support. Her parents insisted absolutely not. She needs to be kept on life support forever. And this became a huge religious and social discussion throughout the country, not unlike what's going on today with the social discussion that we're having right now over race. This was a huge, had a huge social impact on the country. Deep divisions for religious purposes and social reasons. Her case went to the Supreme Court several different times at various stages for decisions. And ultimately, the Supreme Court decided that she could be taken off of life support. Now, all of this could have been avoided if Ms. Schiavo had properly executed that simple document, that healthcare directive and that living will. But because of Terri Schiavo, now almost everyone is familiar with that, because we know now what can happen if we don't do it. And she brought this to our social consciousness, and now, you ask anybody, what's a healthcare directive, and almost anyone can tell you exactly what it is. Most of you have probably already executed some kind of a healthcare directive or a living will. And I can almost guarantee you, for many of you, it's been years, it's probably out of date, and probably won't really work when you need it. And if it has been a few years, it's probably not even comprehensive enough and to provide enough detailed guidance on how you would want to be cared for in the event that you do become incapacitated. So I want you to be sure, I've been talking a while, make sure you've completed section 4 of your workbook, planning for my terminal illness, coma, or vegetative state, because that's what the healthcare directives are for. So maybe you're saying, well, John, I haven't done this, or yeah, it's been years since I completed one of these healthcare documents. I don't know what's changed. And if you want to make sure that your wishes are comprehensive and that they're honored at your capacity, if you have specific wishes for how you would want medical decisions made for you. Keep listening and take advantage of the special offer to meet with me that I'm going to present at the end of the workshop, because that's definitely something that we will want to discuss with you. All right, we've gone through 4 of them. We're on number 5, planning for your death. This is probably the most important decision you should make, because this allows you to remain in control of what happens when you die. And you don't leave it up to a court to decide, and you don't put your family in the middle of conflict. So let's talk about your estate plan. In an estate plan, there are 3 possible scenarios. Number 1, you have a will. Number 2, you have a trust. Or number 3, you have not done any planning yet. This does not mean that you do not have a plan, because if you haven't done any planning, the state of Arizona, they have a plan for you, and you may not like it. You may not like it how the statute says where your money will go, who gets how much, but if you don't plan ahead, then you just have to take the state's plan as it comes. So now, with that in mind, I've asked you to complete the first part of section 5 in your workbook, My Current Estate Plan. Which of those statements best describes your current status? Now, assuming you have created a trust or will, when was the last time you had it reviewed? Because of changes in your circumstances, possible changes in the law, your estate plan should be reviewed at least every 3 years. In addition, you should make sure your plan was created with a lawyer who made sure your plan will work when your family needs it most. And we're going to talk about what kind of lawyer that is and what kind of lawyer that is not in just a moment. So let's see here. The state's estate plan for you, kind of a little tongue twister. If you have not created an estate plan and you become incapacitated or die, as I said, the state already has an estate plan for you. And if you become incapacitated and you go to court so the judge can appoint someone to make decisions for you, to be a guardian or a conservator, we call that guardianship, and that happens in the probate court. If you've died and your family takes your will to court, or somebody goes to court and says, we don't know what to do, mom and dad died, they didn't leave a will, then we call that probate. So both of those happen in the same court. One of them is called living probate. So if you're going to get guardianship or conservatorship, or someone's getting that over you, it's called going through living probate. Otherwise, if you've died, it's just called probate. Here's the deal. If you don't have a will, you don't have a trust, the court will decide where your money goes and how much goes where. And it most likely is not what you would choose yourself. Now, even if you have a will, your family will go through this exact same process. The only difference is that with a will, you get to decide who will receive your assets when you die. Otherwise, the probate process is exactly the same, with or without a will. So if you look at the graphic on your screen, you can see that this is potentially very expensive. There are attorney's fees, executor's fees, appraisal fees, bond premiums, creditors that have to be paid, court filing fees. And it takes time. This is a slow process. It drips through this pipeline slowly. In Arizona, you can count on at least 9 to 12 months to get through this process, often longer. We've had probates that extend, past 2 years. So it really kind of depends on the specific situation as to how long it will take. During this time period, your creditors are getting paid, but your loved ones, the people who you want to receive your assets, are not getting access to those assets. So who would you rather have getting access to your assets? You know, the creditors or your children? So the other thing about this is that someone has to be appointed by the court to be your personal representative, who we used to call an executor. For that person, this is an exhausting process. There are numerous steps in bookkeeping and meeting with appraisers, going to court, things like that that they have to do. And so I would say just about everyone that I've talked to has been a personal representative has told me that they really would never like to have to do that again. So that's a little bit about probate. It's a court procedure. We had to petition the court. We had to go through the court process. We had to pay the money. We had to pay the creditors. We had to do a lot of things in that time period. And then ultimately, your family will get access to your assets. So now would be a good time to start completing the section called probate in your workbook, and that's on page 4. So here's the other thing about probate. It's a totally public court process, meaning anyone can go down to the courthouse and pull your court records to see what you own and who is getting it. For example, what you're looking at right now is the will of Jackie Kennedy Onassis. You know, would you like to see the will of John Lennon, JFK Jr., Babe Ruth, Jerry Garcia? You could, because they all went through the court process, and those are open public records. So my point here is that a will is public and it does not avoid probate. And that's a common misconception that people talk to me. But I have a will. Why do I have to go through probate? A will has to go through probate. It does not avoid it. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money because it's a public process. The only plan that's private, avoids probate, ensures your children receive your assets when you want and how you want, and can save you substantial estate taxes is a properly funded trust. But we're going to talk more about that later. But just so we know right now, a will does not avoid probate and it is public. And finally, worst of all, if you have young children, your children would be entitled to all of your assets outright without any restrictions, without any protections at age 18. And I'm sure you can imagine what your 18-year-old child would do if they suddenly inherited your life insurance policy. So enough said there. We were all 18. And finally, you may want to ensure that your kids receive their inheritance protected from lawsuits, protected from future creditors, bankruptcy, or even a future divorce. Most adult children have no idea how to keep an inheritance separate from their community property. And as a result, they will typically lose half of it to a future ex-spouse during a divorce, or lose much of it to a bankruptcy court or to a lawsuit. However, if you leave your inheritance for your children in a protected trust, your children will be able to keep all of it, even if they get divorced, even if they file bankruptcy, even if they have a court judgment against them. So now I want you to go back to your workbook and complete parts 2 and 3 of section 5, probate and the state's plan for probate. And we're going to move on. So while you're completing your workbook, let's talk about another will-based plan, Aretha Franklin. Beautiful, beautiful spirit and soul in Aretha, beautiful voice. But Aretha died a couple of years ago, leaving behind 3 adult children. One of her children has special needs. over the course of about a year, her family eventually found 3 different wills, each leaving her multi-million-dollar estate to her children in different amounts. Each will was different. In one of her wills, she even disinherited completely her son with special needs. The result, Aretha's family will be spending much of her estate fighting over which will the court should admit to probate. And it's going to probably take years and thousands, if not hundreds of thousands of dollars, possibly even into the millions, to have this fight over her estate. So speaking of Aretha Franklin's son with special needs, how could she have done things differently? First of all, she could have established a revocable living trust and avoided having her children fight about which will to probate. Then she could have set up a special needs trust for her son, which would have protected his inheritance from outside influence while ensuring he could always get access to public benefits if he ever needed them. I don't go into detail in this workshop, but I do discuss these options in greater detail in my other workshop, the 5 critical steps you must take to plan for the future of your child with special needs the right way. For now, if you have a child with special needs, complete this section of your workbook on page 6, My Loved One with Special Needs. And if you want to know more about our special needs workshop, contact us and we'll have an email up at the end of the workshop so you know where to send your question. So going back to probate and wills, you know, a lot of people think they can avoid all this probate stuff by getting creative and owning property jointly, designating a beneficiary for their assets. Some people even believe that signing a will avoid probate. But if we look at, for example, joint ownership, there can be a lot of problems that arise out of joint ownership. You probably remember when you were buying your home, you were in escrow, and the escrow agent asked you how you wanted to take title to your home. And if you're single, you probably said, oh, just in my name. But if you're married, more likely than not, you probably said as joint tenants with right of survivorship. And if you said that you want to take the property as joint tenants, you know, you have some benefits. Upon the death of the first of you to die, that property does not have to go through probate. But the downside is the surviving spouse could get remarried and lose that house in a divorce. The surviving spouse could lose that house to creditors or give it away to a future spouse. You know, there's no control over what your surviving spouse might do with that asset. And with the joint tenancy, the surviving spouse loses the benefit of erasing all the capital gains on the property in death. Now, in Arizona, as a community property state, if you took title as community property, then you do get to erase all the built-in capital gains. It's called a step up in basis when one of the joint tenants dies. But here's the trade-off. 1/2 of the property has to go through probate. So either one of those options, while they have benefits, also have problems. And so they're not necessarily the best way to avoid probate. The other thing, you know, that we do in Arizona, it's a great option that we have here, is called a beneficiary designation, or designating a beneficiary where the asset permits it. A lot of assets don't permit beneficiary designations, but where you can designate a beneficiary, the beneficiary at your death will have unlimited control over the assets. So if you give your house to your children as joint tenants with right of survivorship, they could lose it. They, you know, divorce, bankruptcy, lawsuits, any number of ways. If you've named a minor as a beneficiary, you're going to end up, your family's going to end up in court because a minor cannot inherit. So that is another issue to think about. And as we already talked about, signing a will not keep you out of probate. Here's another thing that people often will do is they say, well, here's what I've done, John. I've put my children as signers on my bank account. That way, if I become incapacitated or if I die, they have instant access to all my cash. Sounds like a great plan. Here's the problem. If your child gets sued or files bankruptcy or has anything like that happen, as a signer on your account is subject to their problems. And so a cash value that you may have spent time, saving up into a savings account or a money market account, and you put your child on them, they get in trouble, they could decimate your entire savings. So I really try to encourage people, don't do that. There are better ways to protect your assets and to make sure that your family does not have to go through probate. So as I've already kind of mentioned, there is a better plan. That plan is called a revocable living trust. When you create a trust, you get to choose how to distribute assets to your heirs. They don't just automatically get everything at age 18, but they can receive it at a schedule that you determine. For most families, we'll distribute assets to the beneficiaries at ages or stages. For example, we'll say, well, they get 1/3 at age 25, 1/2 at age 30, and the remaining balance at age 35, or they can get 1/2 upon graduation from college and the rest upon graduation from graduate school. So this is an acceptable way to plan, but there's even a better way, and we're going to discuss that next. How many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, can never be taken away in the event of a divorce? Of course, we'd all like that. Now, what if I said, well, you can do this, but you don't get to control those assets? You're probably going, oh, wait a minute, John, what's the catch here? I'm not quite as interested now. Well, in our living trust, you can give your children assets that can never be touched by creditors, will never be subject to estate tax, can never be taken away in the event of a divorce, and you can give them complete control. These are cutting-edge planning techniques that only the most knowledgeable estate planning attorneys are taking advantage of, and I'm betting most of you would want to include them in your plan. So while I move on to the next slide, go to your workbook, complete the section entitled Protection of My Assets from Divorce, Creditors, Lawsuits, or Taxes, and that's on page 7 of your workbook. So the only way to keep your family out of court in the event of your death or your incapacity is to have a fully funded living trust. This means that you've got a trust prepared that is properly custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or your death. And all of your assets are owned in the name of your trust. Critical point. Trust does not work if you have not transferred your assets into the name of your trust. Now, if you already have a trust, chances are you've never gone back and updated it since you created it. And it's likely out of date if it's been more than just a few years since you created it. Because in 2020, the law changed. And if you have an IRA, then your trust is out of date already. Your assets may have changed, and you may need to take another look at that. It's more often likely that your assets are not even properly owned in the name of your trust. Time after time, I sit down with clients, and they'll say, John, can you look at my trust, make sure it's okay? The first question I ask them before I even look at their trust is, what assets are owned in the name of your trust? And I would say well over 50% of the time, they look at me with a blank look on their face, like I have no idea what you're talking about. And we start looking at their title to their home. We start looking at their bank accounts. We start looking at their investment accounts and their IRAs and their life insurance. And none of their assets have been transferred into the name of the trust. They spent thousands of dollars for a fancy binder and fancy paper that absolutely will not work when their family needs it to work most. I had a couple sit down in front of me a couple years ago, and exactly that same thing. And they had had this trust for 11 years. For 11 years, they were living under the false premise that they had a rock solid estate plan in place. And very first thing I asked them, what property is owned by your trust? They got that look on their face, and immediately understood that they had to go back and start over and do things right. And here's what I found out. They used one of those lawyers. Every lawyer out there can tell you they can do a will for you, they can do a trust for you. The reality is they can produce a document, but they cannot produce an estate plan. They cannot make sure that your plan will work when you need it most. And that's what this couple had done. And that attorney gave them beautiful documents, never made sure that the rest of it was complete. And if something had happened to them, they would have been shocked to find out that their entire estate would have had to go through probate. So if you do have a trust, go ahead and complete section titled in your workbook, My Trust, on page 8, and just kind of jot down what your reality is right now as it relates to your trust. All right, finally, what about estate taxes? Well, unfortunately for most of us, right now, that's not an issue. Because unless you have assets totaling more than $11.4 million, or you're expecting an inheritance of greater than $11.4 million, that would put you in that category. Today, you don't need to worry about estate taxes. What we do know is that in 2020, we could very likely end up with a new administration. We could end up with a Senate and House under different control. And in that case, it's very likely that this $11.4 million estate exemption tax will be lowered. This past year, our government has gone trillions of dollars into debt to try to keep our economy alive. And they're going to have to try to find a way to pay that back. And estate taxes are valued at billions and billions of dollars a year coming in through estate taxes normally. So I would not be surprised at all next year, if the administration party changes, to see this $11.4 million exemption reduced down significantly. We don't know how far it could go, but it could be a significant reduction, putting more and more people in a place where they do have to do estate tax planning through their estate plan. So while this doesn't apply to most of us, if this applies to you, if you have more than $11.4 million, or if you're expecting that inheritance, go ahead and go to page 8 of your workbook and complete that section called My Estate Taxes. All right, so here's a bonus. We gave you 5 most important decisions you could make. We talked about getting organized, making sure your children are properly cared for in the event of your incapacity or your death. We've talked about making sure that if you become incapacitated, you've made plans for all of your financial affairs to be taken care of without your family having to go to court, without somebody you don't choose becoming in charge of all your finances, or in charge of you as a guardian. We've talked about what to do about making sure that your healthcare decisions are done by people that you choose and that you want, that you've got proper permissions in place for the people you love to talk to the healthcare providers and the hospital staff and get information from you. And we've talked about how to make sure that when you die, you've done all the preparation possible to make sure that your family stays out of court and stays out of conflict to the greatest ability that you have. So here's the bonus. I want to talk to you about planning for your legacy. And here's a question I want to ask. If you had to choose between the people you love receiving your money or your values, insights, stories, and experience, which would you choose? Most people say that if they had to choose, they would choose to pass on their non-monetary assets, their intellectual, spiritual, and human capital over money to their children. So it makes no sense that most estate plans completely ignore this aspect of planning altogether. You know, my dad, he died, over 20 years ago. And just before he died, he told me, he said, John, I have one regret. And I said, what's that, Dad? And he said, I just regret that I couldn't have left all of my children an inheritance. And, he's a sweet old guy. And he's like, I wish I could have left each of my children $5,000. It's like, Dad, I said, we don't care that you didn't leave us any money. What we care about is that you left us your legacy. My dad, took me everywhere with him when I was younger. And he taught me how to be a carpenter, how to paint, how to be an electrician, how to be a plumber. He taught me how to speak in public settings. He taught me how to teach. My dad was just this amazing, multi-talented person. And that's my inheritance from my dad. And, because my dad died, some 20 odd years ago, we didn't have digital recordings and we didn't have Facebook and all that stuff when he died. And I had no recording at all left behind of his voice or his image other than photographs. And, there are times I would get anything just to be able to hear my dad's voice again, because he was such a force in my life. My dad was a true legacy for me. And I know that for the community at large as well, because he had a huge giving heart, and the community loved him for that. So one of the most valuable gifts you can leave your family is that of your values, your stories, your insights, and your wisdom. That wisdom that's earned by your life experiences. Collectively, this is your legacy. This gift to your children is legacy. And some of you don't have a lot of assets, and that's okay, because what your children really want from you is your memories, the things that you taught them, the stories that you've told, the wisdom that you've imparted. So, as I quickly go through these next few slides, I'd like you to go to your workbook, go to page 9, and just start jotting down some notes to help you remember what those values, stories, and wisdom are that you would want to pass on to your family. So your legacy is about your loved ones having your insights, your values, your stories, and your experiences as a way to remember you. What's most important in this process is that you actually sit down and do it. Collect those stories, collect those experiences. If you have young children, start now building that legacy with them. This is my dad did when I was young. And as an attorney, I don't feel like I'm serving you well if I just draft legal documents for you and don't even touch on the fact that your legacy is more important than what we just did with those legal documents. So, that's a big part of my purpose in life. As an attorney, a parent, a son, as a husband, this is the reason I'm here, helping clients and families get an estate plan in place and begin to capture their legacy while they do it. Whether you know it today, you have a legacy right now, but maybe it's not the legacy you want to leave your family. You can start right now creating the legacy you want your family, friends, and community to remember you by. And you start by asking yourself two simple questions. What do you value most about your life up to this point? And secondly, if time or money were not an issue, what would your future look like? What would the future look like for you? What would the future look like for your family after you're gone? Now, I'm not going to go into the full explanation of how we dig down into all of this, but I want you to know that these are the questions that start the conversation about legacy. And I want to plant those in your mind because I want you to understand one way or another, you're leaving a legacy. And it's going to either be the legacy you want to leave, or it's going to be the legacy that you've neglected and left by accident. So here's 5 areas, and I like to call this fishes: financial, intellectual, social, human, and spiritual. It spells fishes. So what does this mean? Well, these are the areas where I would invite you to start looking at your life and looking at your past life and looking at what your life could look like in the future. From a financial standpoint, we're talking things like your business, starting a family foundation, getting your estate plan in place, making sure you have special needs trust in place if you have children with special needs. From the intellectual standpoint, what knowledge and skills do you have or will you pass on to your children? From a social perspective, are you exposing your children to your connections so that when they become adults, they have connections and a network to help them be successful? This is something that I really never thought about when I was raising my children, and this came to my awareness, sometime back. I was like, what a great way to really help your children is to make sure that your business network and your financial connections, that your children know who they are and are familiar with them, so that as they become adults and they go into college and they need a reference, or they come out of college and they need a job, they've got a network of your connections that can help them become successful adults. Then we get to the human side. What are the stories, the wisdom, the life experiences your family and friends and community will remember you for? Capture those, develop them, write them down, write a book, whatever you need to do. Capture all those stories. And finally, from a spiritual standpoint, I'm not talking about religion, I'm talking about spirit. What spiritual guidance do you provide your family? Are you there for them spiritually? Are you present for them in that way? So again, I'm not going to go into all the details. I wanted to give you a taste of what it means to start creating the legacy you want to live. And speaking of legacy, I think that it's really important to understand that not everyone comes into estate planning from the same place from a religious perspective. There are many, many facets of different religions that have to be taken into account during estate planning. For some religions, cremation is not an option, or you can be cremated, but the ashes cannot be taken into the temple or the church. For others, you're not allowed to have blood transfusions, and that needs to be captured in your estate plan. Some religions actually dictate how your assets can be divided, how much can go to charity and how much can go to different members of your family. So these are areas that when you begin to work with an attorney to do your planning, if you have any kind of religious restrictions or guidance, I should say, on your estate planning, find an attorney who understands that and who knows how to incorporate that into your plan. So we're about finished, but before we move on, I have one last story to tell you. I told you lots of stories. I got one more. Back in the 80s, I was training in South Texas to become a paramedic. And we took a field trip over to Mexico to visit one of their small Red Cross hospitals over there. We were taking a break. We were standing outside, and a Red Cross ambulance van, very similar to the one in this picture, pulls up into the hospital bay. The driver gets out. The passenger gets out. Both of them are wearing white shirts with a little red cross on them. They go stand over the wall, lean back, start talking, start smoking a couple of cigarettes, and I figure, oh, they're taking a break. A few minutes later, I see the side door open, and it just slides open, and I see a hand and a foot and an IV pole, and this obviously term pregnant woman climbs out by herself out of this ambulance and takes the long, slow walk up the ramp into this emergency room. And I was shocked because, we were trained much differently than that. You never let your patient walk by themselves. You take care of them until you handed them off to the next level of medical care. And I'm sitting there, I'm watching these guys stand over there, leaning against the wall, smoking. I'm watching this pregnant woman walk up the ramp, carrying her own IV pole. And it just had such an impact on me. Today, this is Mexico Red Cross in advanced pre-hospital training. Over the past 20, 30 years, they have recognized their shortcomings, they have sought the training, and they have become a very professional, advanced level pre-hospital care provider in most areas of Mexico. In fact, one of my former students has an international EMS training company. He goes all over Mexico doing this kind of training for the Mexican Red Cross. Why am I telling you a story about EMS and ambulances in Mexico? For a very simple reason. When you look on Google and you look for images for lawyer, these are the kinds of images that you're going to find. And when I see these images, I get this idea of a traditional lawyer. A traditional estate planning lawyer, will do a transaction with you. So one-time transaction. Hey, Mr. Lawyer, I need a will. Certainly, here's your will, here's your money, we're done. You get form documents like that couple I told you about who had a trust for 11 years and didn't have any assets in it. They got a traditional lawyer who gave them form documents. And just like that couple, you may or may not avoid conflict. You may or may not avoid probate. You may or may not avoid estate taxes. You may or may not leave your assets to your heirs protected from creditors, from divorce, from lawsuits. More than anything, I can almost guarantee you that you will not get ongoing legal guidance for your estate plan. Over and over again, I have clients, I ask every client who has a will, I say, who drafted your will for you? And 99 times out of 100, not even 9 out of 10, 99 times out of 100, they can't tell me. They say, I don't know, it's some guy in a suit in one of those fancy buildings downtown. I don't remember his name, because they've never been in touch with them again. And I can almost guarantee you, based on my experience working with these clients, that the lawyer has done nothing to make sure that your assets are not lost to the State Department of Unclaimed Property. So here's what you get. If you do your documents and your forms online, there's going to be holes in it, and you could really end up leaving your family in a big mess. We know what doesn't work. Absolutely, doing nothing doesn't work. Having a will or getting an estate plan created by a lawyer who just focuses on documents, or doing it online yourself might work, but probably will not, because it probably won't ensure the protection of your kids if you become incapacitated. It probably will not make sure that your assets are properly protected when your children inherit them. It probably will not make sure that your assets are owned in the right way. And it absolutely will not help you create and capture your legacy. So here in our office, we decided that there's got to be a better way to take care of our clients. And we call this planning for life. You know, the other way is planning for death. Documents that don't work, online wills, that's all planning for your death. We like to look at this as planning for your life. And it's a whole new experience. It means that you're going to find an attorney who educates and informs you so that you get to make empowered decisions. An attorney who knows how to ensure your assets are not lost at your death. An attorney who can create a plan to protect your hard-earned assets from divorce, creditors, and lawsuits, and who knows how to help you capture your legacy while keeping your family out of court and out of conflict, so that you know that when your family needs it, your plan will actually work. Here's how to get started. We begin all planning with what we call a life and legacy planning session. And this is a process. Our clients absolutely love it. You'll love it too, because it supports you to get financially organized, more financially organized than you've ever been before. You keep your assets out of the State Department of Unclaimed Property. It ensures, this life and legacy planning session, that you make informed, empowered decisions for the people you love. So you know that what you actually need to have in place and what you don't. And during the process, you know exactly who you're going to ask to do what, who will step in to make decisions for you. And during this process, you're going to actually choose your own fee for the planning that you do. By the end of that planning session, you'll know with certainty you're making the best decisions throughout your life, and your family will know how much you cared about and loved them in the event of your incapacity or death, because everything will be well handled. Ultimately, like I said before, this is something you do for the people you love. So what I'd like for you to do is go to the bottom of page 9 in your workbook. There's one final question there, and it's called My Truth. Pick one of those. And then just below that, I'm going to ask you to make a promise to yourself that no matter what, you will take the necessary steps to keep your family out of court and out of conflict at your incapacity or death. Now, you're not promising to come see me, but you're promising to do something, to take those steps. And to seal that deal with yourself, you're making yourself a promise. You're going to sign a contract with yourself. Go ahead and sign that workbook and date it so that you can remember that you made this contract with yourself on this date to take the necessary steps to make sure that your family does not end up in court and conflict. Now, I told you that if you stayed with me for this entire workshop, I was going to have a bonus for you. And here it is. And I'm going to ask Patricia to go ahead and make sure that this link is posted in the chat, so you can go to it right now. But I'm going to give you access to my online scheduler. So you can just go right in, you can see what my schedule is, you can pick a time and date that works for you so that we can plan our life and legacy planning session and go get that on the calendar. Now, I typically charge $750 for you to meet with me for 2 hours of education and information and empowerment for you to make these decisions for your family. But my bonus to you as my guest today is to give you access to my online calendar at no charge. So you can schedule your personal life and legacy planning session with me one-on-one to get started on your estate plan. Now, I want to emphasize that I provide my online scheduler at no charge only to people who get this far. All you have to do is go to the website you see on the screen. It should also be up in the chat box, HiltonLawPLC.com/schedule online. Click on that link and you'll go to my calendar, and there you can schedule your 2-hour meeting with me. If you schedule within the next 24 hours, in addition to getting you on my calendar at no charge, I am going to actually give you an additional $250 off a trust plan if you decide to create a trust with me. So when you go to HiltonLawPLC.com, schedule online, at the bottom of that form, you'll see an area for a promo code. In that promo code, in order to receive these gifts, $750 worth of my time and $250 off of a trust plan, so $1,000 total, enter into the promo code I attended at the bottom of the scheduling form. Now, I don't take very many clients every month. My time is very limited. I offer appointment slots on a first come, first served basis. So now's the time, if you want to get one of those slots with me, to go to HiltonLawPLC.com, schedule online, and reserve your 2-hour meeting. Again, no cost because you've come this far with me. Be sure to enter the promo code I attended at the bottom of the scheduling form, and if you do that within the next 24 hours, I will throw in an extra $250 discount towards your trust plan. All righty, so we still have some time, I believe. What are we looking at here? Trying to see how much time we have left. Hey, Patricia, can you come on?
Sorry, John, I was trying to get my equipment to work. Can you hear me? John, can you hear me?
Let's see if I can get Patricia unmuted. There she is.
Can you hear me? All right.
All right. So how much time do we have for questions?
We actually have almost a half an hour. I do have a couple questions already in the queue.
Okay.
First question is, I don't have a large estate. Do I still need a trust?
You know, it's a great question. And, you know, I love answering this question because the prevailing notion out there is that only the quote unquote wealthy need a trust. The Rockefellers, the Trumps, the Gates. That is no longer true. That's not the position we take. For us, having a trust is not about how much you own. You know, if you talk to a lot of attorneys and advisors, they believe in this qualifier that, well, if you have less than $100,000 in assets, you don't need a trust. If you have more than 100,000, you do. Others will say, well, no, you don't need a trust unless you have more than $500,000. And others will say a completely different number. Depending on who you're talking to, you know, you're going to get a different amount. And so it's really not a good indicator. It's very arbitrary what these advisors will tell you about when you should or should not consider a trust. So what we do instead is we focus on educating our clients about how a will works and about how a trust works. Specifically, what probate court looks like and what it would look like if they didn't have to go through probate with a trust. That way, our clients get to make the choice. Some will say, you know what, I'm fine with probate. I just want to do a will. We say, okay, that's great. Others will tell us, I don't have that much, but I don't want my family to have to go through probate. I'd like to do a trust so that my family can avoid going through that process. So it's really about our clients being educated about what they want their loved ones to experience when our client is no longer there. So for us, it's not about how much you have, it's about the quality of the experience that your loved ones will have, rather than some random dollar amount that really doesn't mean anything about who does or does not, quote unquote, qualify for a trust. Hope that answers the question.
So here's another one, John. How long should I plan to set aside for the life and legacy planning session? And what are the payment options?
Okay, great. So we just talked about this. This is probably came in before I addressed this, but typically I block off 2 hours for your life and legacy planning session. You're welcome to use as much or as little of that time as you like. Before we meet for your planning session, you're going to complete an online, it's called a personal resource map or a life and legacy inventory assessment that provides us with key information about you that allows me to actually make sure that I'm providing you proper legal counsel. And during our meeting, I'm going to ask you a lot of questions. You'll have questions from me. I'll review various estate planning options with you. I'll review the fees with you. And then we just jump right into designing your plan. And that means that we start talking about the kind of plan you want, who your beneficiaries would be, who your heirs are, who your personal representatives or your trustees are. We start going through that whole process of getting your plan designed. Once we get through that, then usually we have you sign an engagement letter, and then Patricia will come in, and Patricia talks to you about our payment options. And we have several options. You can pay 100% up front. You can pay cash, check, credit card. You can pay half down when we do the design, half later. Patricia's pretty creative in trying to make sure that we work with you to make sure that you can work out a payment option that works for you. In addition, we actually also offer a really easy legal financing option through a third party. So some people who need to take advantage of that, it's just like going on, some of these other like LendingTree and these others, you put in some basic information and you'll get contacted by a few lenders who say, hey, we'll lend you this money, X percentage rate, X amount of time, based on your income and your credit score. So we have those options. We have, so lots of different ways to figure out how to make payments.
So John, this one is they're planning on having more children and wondering if they should wait to do their estate plan to make sure that these additional children are covered.
All right, yeah, great question. And the answer is absolutely no, do not wait. What you'll find in our plans is that we talk about a child or children, and we define that within all of our plans as including future born or future adopted children. So, get your plan in place, don't wait. If you have a child, it's automatically included in that plan. So we don't want, a growing family to feel like they need to wait until their family's in place, or every time they're going to have another child, they have to come in and make a change to their estate plan. We keep that plan current, and more important than anything is that you have that plan in place so that your children are protected and never left exposed and vulnerable. So you're always welcome to come back in and update your plan and add your children's name to it. But if you don't, your plan will work anyway.
So John, this couple actually said they have existing estate plan documents. How does this fit into the estate planning options that you have available?
Great question. We run into this a lot. So as part of the life and legacy inventory assessment that we have you complete before you come into your planning session, in that we ask you if you have any existing estate plan documents. And if you do, I ask that you scan and upload those documents to us so that I can review them in advance before we meet. If you have an estate plan document that is as comprehensive and detailed and tailored as I would personally draft it, then I'm not going to redo it. I'm just going to tell you, hey, this is a great document, and we'll just fit it into your plan, as is. But if it's not, then I'll let you know that this is how I would do it. This is what I would add. This is what I would change. And we'll educate you, and you'll make those decisions about how to either integrate it or make those changes to your plan. And depending on what it is, if you already have an existing part of your plan that I feel like is perfectly great and doesn't need to be changed, we'll try to adjust the fee for your plan so that we're not charging you for work that we're not doing. The reality is typically those fees do not get adjusted significantly because we don't charge by the hour. We're charging by the value that we give in helping you put together this plan that will absolutely work and that will work for you for the rest of your life. And so, there will be some adjustments, but they're not usually like significant, like 30% off because you already had a document in your plan.
Great. So John, this person asked if we do, wait, let me reread this. If we have an estate plan in Arizona, we write an estate plan in Arizona, but then I move to a different state, what happens?
Yeah, boy, that comes up a lot too. So any estate plan drafted in Arizona is absolutely good, legally enforceable in every state. Now, you might consider, if you become a resident of another state, considering that you could actually be subject to the inheritance laws of two different states. Because if you buy property in the new state and your estate plan is still an Arizona plan, then you've got your new state's court and the Arizona court who could be controlling that process. So we always recommend that if you do go to another state, that you consult with an attorney in that state, and just make sure that if there are any nuances in that state's law, especially when it comes to, for example, if you buy a house and you want to make sure that you put that house into the name of your trust. Some states have different laws about how to do that. So you want to talk to a local attorney and just make sure you're doing all that correctly.
Okay, great. John, this gentleman asked if with all of the plans that we have, are there any kind of specific prices for a supplemental needs trust or a special needs trust?
Yeah, so great question. Typically, if we are creating a plan and adding a special needs trust to it, so whether it's a will plan or a trust plan, the special needs trust is $1,000 flat fee.
Great. So you prepare the documents for me. Who should get copies of my estate plan?
Wow. Well, that all depends on which documents we're actually referring to. When it comes to your actual will or trust, that doesn't need to be shared with anybody. I would recommend, that you keep that in a safe place. I also do recommend that families discuss their plans with their children and others, who are part of that family, if they're comfortable doing so. But they do not need to give copies of their will or trust out to anybody else. However, when it comes to things like your durable power of attorney, your healthcare documents, your living will, healthcare power of attorney, that type of thing, anyone you've named on those documents should have a copy of that document, because if they have to step up and begin making healthcare decisions for you, they need to know what kind of decisions you want made, and they need to have a copy of that to prove to the healthcare facility or the healthcare provider that they actually do have the authority to make decisions for you. And the other area is in our kids protection plan. If you've named short-term guardians for your children in the event that you're incapacitated or you're waiting for your permanent guardians to get there and for the court to go through that court process, we definitely want to make sure that they have the appropriate copies of the documents that they need. This is something that we take care of for you. You don't have to mail out a bunch of stuff. Once your plan is complete, we sit down, we talk to you about which documents need to go out, and we take care of mailing them out to the appropriate people for you.
Well, John, we have congratulations in the room here, but this individual is asking if there's a way to expedite the process if I'm about to have a baby.
Woohoo! Yes, absolutely. We can expedite the process. So what we would do is, we typically run on a 4 and 8 week calendar. So after we meet for the design meeting, we'll meet 4 weeks later to sign everything, and then 4 weeks later to give you your binder with all your documents and go through some other formalities. We can always expedite that process and work around your due date to get a plan in place. It does mean that there's a little bit more work on your end, getting documents back to us, but it's definitely something that we can accommodate.
So John, this couple says, if we are a blended family, do you recommend having one trust or two?
Well, that's a great question, and I'm going to give you the lawyer answer. It depends. So what it depends on ultimately is how you want to handle your assets. If both spouses are coming into a blended family with, they each have children, they're both successful in their own rights, they both own their retirement plans and everything, and they want to keep all of that a separate property because they really don't, they want their assets to go down to their own children, then we might be looking at separate trusts. Other families come in and they just bring everything into the marriage. They commingle all their assets. They immediately get joint bank accounts. They put each other on their life insurance, and they treat all the children as the same. And for that situation, we would definitely want to create just a single trust for the couple. Things can get sticky during this process. If they're surviving, if one of the children, one of the spouses is a surviving spouse of a deceased former spouse, their spouse has died and now they're remarrying and they have children, that can get sticky. If their former spouse has gotten remarried and their spouse now has children, and now you got multiple blended families in the mix, things can get really sticky really quickly. So sometimes we look at those situations and we say, well, maybe in this particular instance, a separate trust for each of you would help eliminate some of the stickiness and some of the risk. So really it comes down to us, again, educating you and informing you, showing you what those risks are and what the potential conflicts are. and then guiding you to a decision that works for you, whether to do one or two trusts.
Hey, John, we have a kind of a two-part question here. It says, if I have a family member that I would never want to allow to be a guardian of my child or children, how do I protect them, my children?
Well, this kind of comes to, man, we get this, unfortunately, we get this question so often, mostly, unfortunately, young mothers coming in who've been in abusive relationships. And it's really heartbreaking to have to deal with this, but when we work with you to create your personalized estate plan, we work it out so that you don't have to worry about somebody raising your child that you would never want to raise them, or with whom they may not be safe. So we do this several ways. We name in your will who you would want to be the guardians of your children. And now we understand that this is a nomination. The court does not have to go by what you place in your will, but they'll give it a lot of weight. We also create external documents to support the will. Again, listing who those guardians should be and what your first choice is for a guardian for your children. We also do the same thing for short-term guardians, making sure that we get the right people in there and the right people have legal authority to care for your children. So far as making sure that you protect your children from this one person that you would never want to be in charge of your child, to raise your child, what we do is we actually create an exclusion letter, and we write down who this person is and why you believe that they would not be the right person to raise your child. A lot of common reasons we get are drug addiction, spousal abuse, porn addiction and exposure to the children to pornography. Very valid reasons that a court may say, no, this person, these children cannot be in this person's house. But we write all that down and we put it in a sealed envelope. And if that person ever comes to court and petitions to become a guardian or caregiver or caretaker of your child, we leave instructions that that sealed letter is to go to that judge, so that judge can open it up and read it in the privacy of his chamber and say, wow, I need to take a really close look at this person who's petitioning for guardianship. I really need to make sure that they get questioned thoroughly, and I need to get this stuff out, and I need to find out, if this person is, capable of having a child. And I can tell you that the judges, once they're faced with that information, they're going to look for a way to not have that person ever get guardianship or care of your children.
So John, we have, right now it's our last question. If we put my assets in a trust, is it hard to make a withdrawal, say out of an IRA?
Yeah, actually, not at all, because the way a revocable living trust is structured, you have absolute total control over all of those assets. So you become the trustee of your own trust. You're the beneficiary of your trust. You can sell, give away, you can destroy, you can buy new stuff. All of those assets continue to move in and out of that trust just as they would if you never formed a trust. When it comes to things like retirement plans and life insurance plans, all we're going to do on those is change the beneficiary of that plan to the trust, So there are absolutely no restrictions on what you can do with your retirement plan or your life insurance policy, even though you have a trust. I hope that answers that question.
Yeah, and that's really pretty much it, John. I'm going to also add that we work with you through the whole process with your assets to make sure that you are, if you decide to handle the transfer of that asset, you know, we're here to help work with you on that. Or you.
Yeah, I mean, 100%. If you ever find, you know, if you create a trust and you know, you have questions, we're there always to make sure that you have your questions answered. If you need help figuring out how to answer a form or to do, you know, something online, we're absolutely there to make sure that you have all the support that you need. So it looks like we've lost audio on Patricia, and I don't see any other questions coming in. I want to thank all of you for your attention tonight. It's been my absolute honor and pleasure to be able to share with you a little bit of my experiences, and hopefully I've had the opportunity to educate you, give you information that you did not have before, maybe raise questions that you want answered. And I want to make sure that you know you can contact us and you know, get those questions answered at any time. Now you can see on your screen there's an email address, clientservices@hiltonlawplc.com. I believe that Patricia put that on the chat as well. So you can just click on that. No, she didn't, but she did put the schedule link up there. So if you haven't scheduled yet, go to hiltonlawplc.com/schedule online. You see the link in the chat box. Go there and get on our schedule. If you do that within the next 24 hours, we will give you an additional $250 off your plan, your trust plan. And you'll get this 2-hour meeting at no cost if you put in the promo code I attended. If you have questions, email us clientservices@hiltonlawplc.com, and you know, we'd be happy to talk to you. If we need to set up a short telephone conversation, we're happy to do that as well. So with that, I am going to say goodbye. Thank you so much, and we will see you next time.